Hello, everyone. My name is Michelle Lee. I'm a partner in International Trade Group of Thompson, Hine. Welcome to today's SmarTrade webinar on importing FDA's regulated products, compliance and enforcement issues. Before we begin, I must address just a few housekeeping items. Today's program is being recorded, and we will send a link to all attendees within 48 hours of today's presentation. This presentation is intended for the general information for individuals and organizations on matters of current interest. The thoughts and opinions being expressed today are those of the individual panel members only and do not necessarily reflect the opinions of the panel members' clients, employers, affiliates of Thompson Hine. The content should not be taken as advice, as the views expressed are for informational purposes only. If you have any questions during the webinar, please feel free to use the question box located in the control panel on the right side of your screen to submit questions. We will answer as many questions as we can, both during the presentation and at the end of the webinar. If you don't get to your questions, we will follow up after the program by email or phone. We will be offering CLE credits for today's webinar. Please be sure to complete the verification of attendance survey. A link of the survey is included in the agenda that can be found in the handouts section of the control panel located on the right-hand side of your screen. We will also paste the link in the chat at the end of the program. I will announce the tracking code at the end of the program. In the handouts panel, you can also download a copy of the PowerPoint slides of today, as well as the bios of today's speakers. Today, I'm joined by my colleague, Jim Fraser. Jim is Senior Counsel in our Product Liability Group, focusing his practices on FDA-related regulatory matters, litigation, and transactions. Again, thank you for your interest, and we will get started. Jim, do you want to go to the first slide?
Yep, hold 1 second. Okay, thank you. Thanks, Michelle. So again, my name is Jim Fraser. I'm in the Thompson Hine office and in Thompson Hine's Washington, D.C. office. And previously, I served as an associate chief counsel at the FDA for about 5 years, from 2016 to 2021. So our agenda today, we're going to have 3 buckets of information. First, I'm going to talk about FDA's jurisdiction. Michelle is then going to talk about actual issues you may deal with the importation of FDA-regulated products. And then I'm going to come back at the end and talk about FDA enforcement actions. So FDA's jurisdiction. When I talk to clients about FDA-regulated products, the point at which I like to start is identifying what category of product we are talking about, because the FDA regulates a number of different types of products, and it's important because there are different regulatory schemes for different types of products, and sometimes these can seem quite intuitive. So obviously the FDA regulates food. That's the first name in Food and Drug Administration. But some people might not realize that that includes not only food that you and I eat, but it also includes pet food or food for livestock, chickens, cattle, things like that, which is a pretty huge industry and very important. It's also important to know that FDA doesn't regulate all food, that the United States Department of Agriculture has jurisdiction over some foods. Examples are meat and poultry. And sometimes this gets really specific. FDA regulates certain types of fish, but in other instances, it might be the USDA. It can get very complicated. So when you're dealing with, when you're first thinking about FDA issues and you're consulting with counsel, you want to make sure you are looking at the right area. Another example is drugs. Drugs include not only drugs for humans, but also for animals. But again, another example of how this can be a little tricky is biological products for humans, such as vaccine and blood products, are regulated by the FDA. But biological products for animals are regulated by the Department of Agriculture. So again, you might not always be dealing with the FDA, you might be dealing with another federal agency. And then you have cosmetics, medical devices, and tobacco products. And again, sometimes it might seem intuitive what category a product falls into, but you always need to verify with an expert in the area to make sure you're falling under the correct jurisdiction. I'll give you an example. Sometimes products can fall in two categories. So if you are importing, say, a sunscreen product, a lot of sunscreens are regulated by the FDA as both a drug and a cosmetic. And that can get real tricky sometimes when you're talking about differences between drugs and cosmetics or medical devices. So important to make sure you've nailed down your product category. People come to me quite often and they want to, at the end of the day, they want to make sure that they're not going to get in trouble with the FDA and they're following what they need to do and what potential consequences there are for not following the statutes and regulations. And I can tell you what FDA has a specific statute that identifies what are called FDCA prohibited acts, meaning it is a violation of the law for somebody to do X, Y, or Z. And it has to be one of those specific things where FDA is going to take some sort of action against somebody if FDA feels it's necessary. I can tell you the list of prohibited acts goes on for like 3 or 4 pages. I can't, go into all of those right now. But at a high level, the big thing that FDA often cites people for is introducing into interstate commerce an FDA-regulated product that is either adulterated or misbranded. And I'll get a little more into what adulterated and misbranded is in a second. Or it's introducing something into interstate commerce that hasn't gone through the approval process. So a lot of drugs, they require pre-market approval by the FDA. And if you don't have that approval, you can't move the product in interstate commerce. And this presentation today is on importation of products. So the FDCA defines interstate commerce as including bringing something from outside of the country into the country. It's not just crossing one state line into another state. I used those words a minute ago, adulterated and misbranded. These are product-specific statutory definitions, and I can't discuss them all here, but the way Congress set the law up with the Food, Drug, and Cosmetic Act is, if certain things are not followed, they are just called adulterated. Certain requirements aren't followed. If certain other things aren't followed, they could just be called misbranded. Sometimes it doesn't actually make sense which one Congress picked. It's really not that important which one. You just need to know that those two terms, while intuitively that you might read those and understand what they mean, they could mean something that's not all that intuitive. I think the best example of this is if drugs, medical devices, FDA has regulations for those products called the Current Good Manufacturing Practice Regulations, or CGMP regulations. If a product is not manufactured in accordance with those regulations, the product is deemed adulterated as a matter of law. And that applies whether or not there is something wrong with the product. And this is something when I was at the FDA, I was told, sometimes you have to explain to a judge. FDA would bring an enforcement action against somebody because, say, for example, they weren't following the CGMP regulations in terms of record keeping requirements. That's a big important part of CGMP regulations. And a judge could say, okay, well, they didn't keep the records, but is there anything wrong with these products? Did you test them? Are they contaminated in some way? You explain to a judge, well, no, judge, there's nothing wrong with them, but because the regulations weren't followed, they're adulterated as a matter of law. And the reason for that is Congress set the system up so that corrections are made before a problem actually occurs. It's not sort of a no harm, no foul analysis that the FDA does. So that's one example of how a product can be adulterated, but there are several others. Misbranded, when something is misbranded, it tends to have something to do with the as it sounds like, the labeling of the product. So if the drug isn't labeled with its FDA approved labeling, or if the FDA has regulations about certain information that needs to go in the label and that information is not in there, that can be an example of a product being misbranded. So how does FDA find out that there may be a problem with a product, even a product that is going to be imported? Michelle's going to talk about the import process here in a few minutes. But a lot of times FDA discovers problems before products actually get to a port of entry, because FDA does inspections and investigations. It inspects factories and warehouses and establishments in which FDA-regulated products are manufactured, processed, packed, or held. And this includes overseas facilities. FDA has at least one office in China, I believe in India. I recently helped a client with an FDA inspection that was in Central America. So this is something that FDA sends inspectors out into the field, into these factories and other places, and generally looking for those CGMP issues. FDA also conduct investigations, which could include just receiving information from competitors or consumers saying, I bought this product, I think there's a problem with it. FDA will go and look at websites of manufacturers and sellers to see if there are indications of a problem there. So it's not just when a product gets to the port of entry in Los Angeles or wherever. FDA is aware of potential problems happening before the products actually arrive. So what happens when FDA identifies a problem with a product, even a problem with a product that may not even have been imported yet into the United States? So when FDA does a facilities inspection, an inspection of a manufacturing plant or some other facility, whether it's overseas or in the United States, at the end of the inspection, if the inspector has observed things that in his or her judgment are objectionable conditions at the facility, it's normally a CGMP violation, the inspector will provide what's called a Form FDA 483, which is just a list of, I found this, I found this, I found this. And that is not actually a finding by the FDA, because the inspector is generally required to give that to you before he or she leaves on the last day of the inspection. That person hasn't had the opportunity to actually go back to FDA headquarters and meet with his or her supervisors and go over the information and make a determination of whether there's an actual problem. And there are situations where, people back at headquarters look at the records and determine that, well, I don't really think there was a problem. But in any event, if the inspector believes that there is a problem that's significant, they will provide you this written Form 483 that explains what the observation is. And FDA will give you 15 business days to submit a written response. And that can be a response that explains why you don't think there was a problem, or explaining, we've looked into this problem, here's what the cause was. FDA is very big into the term, it's big into what they call a root cause. So if there was a problem with record keeping, certain records weren't kept, FDA wants to see more than just, well, you went ahead and corrected the records. FDA wants you to look into, well, why weren't the records properly kept? Was this maybe you weren't training your employees properly? Was it maybe a software problem that needs to be corrected? Because a big theme for me with FDA enforcement when I'm advising clients is the FDA, they want regulated industry to come into compliance with the law. Some federal agencies are big on issuing fines, and FDA can issue civil money penalties. But the FDA doesn't get to keep any civil money penalty money that comes in. It doesn't really do FDA any good. They really want to help industry correct any problems. So when you're responding to Form 483s, what FDA is really looking for is that you've gone and figured out what caused the problem and how you've corrected it and how you are going to make sure the problem doesn't happen again in the future. So FDA can get your response to a Form 483, and on some occasions, FDA, after looking at your response, will still think maybe there's more you could do, and FDA can issue a warning letter to you. The thing that industry needs to understand about warning letters is those are typically posted on the FDA's website, so it's not great publicity for you, obviously. Sometimes that can trigger, lawsuits by consumers because plaintiffs' lawyers monitor the FDA website looking for those warning letters. 483s, FDA doesn't publish those. Somebody could get one if they submitted a FOIA request, but that doesn't happen all that often. It's really the warning letter that you have to worry about. And so FDA issues warning letters for violations that FDA considers somewhat significant. But again, when you get a warning letter, you're given 15 business days to respond and convince FDA that you are taking proper steps to correct the problem. And both in the Form 483 context and in the warning letter context, I say that there's a 15 business day time frame to submit a response. Quite often, FDA will come back and ask for more information, and it's an iterative process. So it's not just 15 business days and you're done. Again, FDA is going to try to work with you and hopefully get to a point where FDA says, okay, we are closing out this issue. We are satisfied that you are taking things, that you're taking proper steps. One caveat on the warning letters is FDA is very clear, FDA is not required to issue a warning letter before they take a more serious enforcement action. But frankly, it's really rare that FDA initiates an actual enforcement action in court without first trying to get the company to come into compliance with the issuance of a warning letter. So I'm going to turn it over to Michelle now, and she's going to actually talk about getting those products, through ports of entry and how that process works. And then I'm going to come back at the end and talk about the actual enforcement actions that FDA can take in certain situations.
Thank you, Jim. Yes, so again, I'm Michelle Lee. I'm a partner with the International Trade Group. I focus my practice on assisting on a wide range of import and custom issues, including assisting clients with the FDA-regulated products to clear customs entry, FDA holds and detentions, and customs seizures. So next slide, please. Thank you. And Jim did a great job explaining a lot of terminology that I'm going to walk into. So for all the FDA imported, FDA-regulated product importation, it starts like any other, it starts as the same import entry process, like all the other products. So first, the importer records will collect data required by U.S. Customs and Border Protection, and Customs, which is CBP, really has the authority for all imported products, not just FDA-regulated products, just so that to be clear. Once after the importer records collects data, they will, the importer record need to submit the data to custom broker licensed by CBP. Next, please. And then custom broker will submit the HTS code, which is the harmonized tariff schedule code, and other mandatory product data into CBP's ACE portal. ACE portal is CBP's automated commercial environment portal, which is basically an entry system that allows the custom broker to kind of enter all the data. Now, like I said, CBP has authority for all imported products. So that entry is first made to CBP, And if the product is FDA regulated, like Jim just introduced in the slides, a couple slides before this slide, CBP will forward the entry information to FDA, and FDA has a import entry system called ITACS, the Import Trade Auxiliary Communication System. And through the ITACS system, FDA will begin its admissibility process. FDA can review all the documentation uploaded by the custom broker in the ITACS system. Next slide, please. So I mentioned the Harmonized Tariff Schedule code, HTS code. So what is HTS code? When entry is made for FDA regulated products or all the products, importers or their custom broker entry filer will include the HTS code in the entry submission. The HTS codes are flagged with indicators to help guide whether FDA data is required. And that's essentially what the FD flag is. And the HTS code is a classification code used to provide the applicable tariff rates and statistical categories for all merchandise imported into the United States. It is based on the International Harmonized System, which is a global classification system that is used to describe most world commodities. Now, to determine your HTS code, you can search on the US International Trade Commission HTS page, or you can just engage Counsel if you have questions regarding the determination of your product's HTS code. FD flag is associated with the HTS code. So in the sense that the HTS code for a product will most likely be associated with an FD flag. Now this flag will act as like an indicator, like I said, whether your product needs to be transmitted to FDA for review. So there are 4 FD flags here, which I will get into one by one. But it's important to know that not all the HTS codes will have FD flags. For example, products not regulated by FDA, such as textiles, they will not have an FD flag. And this doesn't mean that the product is not FDA regulated just because they don't have FD flag. Custom brokers, entry filers, based on their own knowledge and experience, may still transmit some FDA data for products that do not have a FD flag on their HTS codes. So we have 4 FD flags here: FD1, FD2, FD3, and FD4. For FD1, it really means that the product may or may not be regulated by FDA. If regulated by FDA, custom brokers will need to submit the entry information to FDA. If not regulated by FDA, it allows the custom broker to disclaim it. So there's a little box for the custom broker in their system say, not FDA regulated. And example include like the chemicals used in manufacturing drug products, they will be FDA regulated. But if it's chemical, is just for industrial use, that might not be FDA regulated. So a lot of time it depends on the intended use of the products. So that's what the FD1 is talking about. And FD2, it means that the product is regulated by FDA, but that product is not food, because food products will have its own FD flag, which is FD4. And FD2 and FD4 doesn't allow the custom broker to disclaim it. So it really means in practice, in practical terms, it's like when your custom broker enter the HTS code for your product, any kind of flag with or it just pops up the FD2 or FD4 FD flags, then it would not allow your custom broker to disclaim the product. And then your custom broker will have to enter the information for the FDA's ITACS system. The examples will include FD2 will include medical devices, drugs, tobacco products, and cosmetics. And then FD4 is just for the food products, again, food, animal feed, and beverages. Like Jim said, sometimes animal feed, even though it's not a food for human beings, it will be regulated by FDA and considered as a food product. Now, FDA3 means that it may or may not be a food product. If yes, submit a prior notice and enter information to FDA. If no, a custom broker can disclaim it. Example will include like salt. So if it's used for treating the road surfaces and not for digestion purpose, then it is not food. But if it's used for flavoring food, yes, it is. So so it depends on the intended use. And many times what you can do is that you can just include an intended use statement and associate that with the import product, so that FDA can find out, okay, this is or the custom can find out this is not a FDA regulated product. And a lot of times some HTS code, the HTS code that will allow custom broker disclaim typically would be some broad categories that, you know, can dump a lot of different type of products in. And by the HTS code, it is not necessarily a FDA regulated product. That's what you will often see, a HTS code that is associated with FD1 or FD3. Next slide, please. Thank you. So all the FDA regulated products have certain commonalities. Section 801 of the Food and Drug Cosmetic Act addresses the imports. Now, the first bullet point on this slide says that all these FDA regulated products must not be adulterated, misbranded, or forbidden or restricted for sale. Now, Jim already explained what adulterated and misbranded and gave everyone a some very good examples. FDA can refuse imports if they appear adulterated, misbranded. They don't have to prove that they are adulterated or misbranded. And I can tell you what's the process involved when there is appearance of adulteration and misbranding in the next couple of slides. Now, adulterated products, like Jim said, are those that are contaminated, not safe, unapproved. Misbranded means that labels contains false or misleading information, or the product is not registered and listed if it required. Certain filing requirements are needed for all FDA regulated products, including the country of production, product codes, affirmation of compliance codes, which are just 3-letter codes that confirm that this product meets certain requirements. Intended use codes, which are number codes that designate either general or specific use and can be critical and determine whether it is even FDA regulated or not. And the contact information for the importer. It's important to know that this FDA regulated products, whether imported abroad or manufactured domestically, have the same requirements. FDA will review the declare, manufacturer, affirmation, and compliance codes and intended use codes regardless. Next slide, please. Thank you. So the common entry errors. It is really interesting that the most common entry errors just errors of entering the data. And you can see from the slide that the most common error is just the affirmation of compliance code. Again, it is 3-letter code that specifies the type of the product. The affirmation of compliance codes can be entered at the time of entry, which just facilitates FDA review. It's not mandatory for all products, but it definitely will expedite the screening and review process, even if it's not mandatory. So given it's the most common entry error, I will encourage you to, if you have a question and problems, determining the affirmation of compliance codes, reach out to Counsel, and we can help you with that. Now, obviously, all of these errors would delay the coming in of the product. Next slide, please. So FDA has trained individuals who will review the entry declarations and evaluate the admissibility of the products. What they can do is that after review, they have like a couple options to do, like they can release the product right after review. That's often the cases, or request an examination of the product, or just request additional information or documents, or recommend that detention of the product right away. So if FDA releases the product, that means the product may be distributed. FDA still has jurisdiction, and it doesn't preclude FDA action if a problem is found later after the product gets into the interstate commerce from the import entry. And the other thing is that it's oftentimes that when FDA is reviewing the products, Custom can do a conditional release. Basically means that the product is going on to FDA for review. It doesn't mean that the product is like free to go, but FDA is actually reviewing, and FDA's review is not a physical hold of the product. So a lot of people will think, why can I ship and take the product if FDA is still holding it, right? I mean, it does definitely means that it's released. No, it's actually just a conditional release, and FDA will still review it. FDA will decide whether they will hold it or detain it or like officially release it. And even after it's released, FDA still can, have jurisdiction over those products. Just so that clear. Next slide, please. And FDA can certainly hold an entry, and during the entry hold, they may request further information, they may sample or otherwise examine the products, and the ultimate decision will be either release the product or detain the product. Now, under the FDA examination, the field personnel will examine some evidence of the product. Among many other things, they will examine whether the product's filthy, what's the decomposition, whether there's any packaging defects, mishandling, or misbranding. And sometimes the examination may uncover some appearance of violations that even the field personnel did not expect, right? And the investigator or inspector can go out to the port of the destination and conduct the examination there. Again, it could include a label review or a sample collection. If a sample is collected, it is packaged and shipped to, it will be packaged and shipped to the appropriate lab for analysis. The appropriate documentation will be completed, and the data will be recorded in the FDA's database. Next slide, please. Now, if after the FDA's holds or after the FDA review, FDA decides that they want to detain the product, then that really means that there is an appearance of violation of the Food and Drug and Cosmetic Act. And when FDA detain the product, it may lead to entry refusal. And what kind of violations? Again, adulteration, contamination, mislabeling, or the product is just forbidden for sale, or it is because the products are subject to an import alert, which allows FDA to physically detain the products without an examination. And at that, regardless, when a product is being detained by FDA, importer could provide the evidence to show there is no violation. This is known as the detention hearing process. And a hearing is not really formal hearing. Sometimes a phone call can deal with that. An importer can submit an application for reconditioning and relabeling. And in that process, you have performed to fill, and then you will kind of tell FDA is a product subject to a redelivery bond, and what's your proposal to recondition or relabel the product, and how many days. And so once you submit that proposal, FDA's entry review officer will decide whether to kind of approve or not, and then you get to opportunity to really do the reconditioning, and then you will submit photos, or the FDA officer can come in to inspect to see if you have satisfied what you propose to do. And then at that point, if they approve and release the product, that product it's good to go. Or if your product still doesn't, so the evidence that you submit or the application of reconditioning have been denied, the detention or entry refusal. Next slide, please. So entry refusal, sorry, I just want to go back to my detention slides a little bit more. Jim, go back to that slide. So it's important to kind of explain what, next slide, please, the detention one. Yes, thank you, Jim. So I wanted to kind of also talk about what detention really means. Like, it's important to know that in this context, FDA detention is not a physical hold or anything. It's just an administrative process. So during this whole detention process, importer often can take possession of the articles, but don't get it wrong. Like, you can just go out and distribute it and sell the products, and you can actually. So FDA basically detain the products, you know, again, like based on the appearance of the violation. You have the right to submit the evidence and refute the appearance. But I don't feel like, you know, just because you can possess the product, you can you can have your carrier ship the product from one warehouse to another warehouse. This means it has been released. It's not being released. Officially being released by Customs. Customs basically just say there's a conditional release pending FDA's, you know, approval to release the product. And FDA's detention is just an administrative process. Next step, please. Again, so next step would be the ultimate decision. If your product is not released and you go through all this, like your FDA holds or FDA detention, and it's still being rejected, then you go to a point where FDA would just enter a refusal to admit your product. If a refusal is FDA's final decision, that the detained product is in violation of FDA laws and regulations. At this point, a refused shipment must either be destroyed or exported under the supervision of CBP, the Customs, and FDA within 90 days of the date of the notice of FDA action, which is the refusal notice. And you know, you might get a civil monetary penalties if the products are not exported or destroyed. And Customs also have authority to collect your bond and issue some fines and liquidated damages at that point. Next slide, please. Thank you. So another tool that FDA can use, and that's related to the import of the FDA-regulated products, is import alert. Import alerts inform the reviewers, the FDA entry reviewers, and the public that the agency has enough evidence to allow detention without physical examination. So basically, if your product comes in and your product is listed on the import alert, it will be automatically detained. And the import alert will provide the information to the field officers, which can then, you know, basically detain the products without any examination. And, you know, import alerts can be country or area-wide. It can be manufacturer and product specific, or shipper specific, or country worldwide alert. There are just so many types of different import alerts. There are import alerts that the whole country's products will be listed under the import alert, will be automatically detained. There are many oftentimes that it will be a manufacturer's product specific. Under the import alert, you will see so-and-so manufacturer or so-and-so companies and X, Y, and Z products is subject to the import alert for, you know, ABC reason. So it is manufacturer and product specific. And even if you, in that circumstance, if your product is the company is on the import alert, but you're importing not the X, Y, and Z imported alert kind of listed products, but some new products, your entry process, your product's entry process is still going to be impacted, because once the company is on the import alert, even if it's not subject to the DWPE, the detention without physical examination, FDA reviewers will look like pay more, basically closer scrutiny to all your entries. So, and then they can find and uncover other, you know, appearance violations and can make a detention decisions based on those appearances, even that is not related to the import alert. And that can often happen. So that's why you don't want your product to be on the import alert, and you want to deal with it as soon as possible because it has like a widespread impact. And there are a couple of types of different import alerts. There's a green list, red list, and yellow list. Red list means that any products on the list are basically no-go or detention without physical examination, to be more accurate here. And whereas the import alert, the green list says that only if you are on the import alert list, all the other products that are not on the list will be detained automatically as long as it fits in the category of the import alert. And yellow list is kind of in the middle ground. So it's like, it's not automatic detention, and the FDA can decide what to do about it. And especially when you're on the red list, you want to file a petition to remove yourself from the import alert, and that is their FDA has a built-in process to do that. What you need to do is file a petition to FDA and show them that quite similar to what Jim just said, what caused the violation, and what do you do with it? What do you think, and what in the future you should make sure you should do to make sure this type of violation will not come back again? And FDA the import operation team will decide whether your petition is good enough to take that product and company off the import alert. Before and also the import alerts informing the FDA's field staff and the public that they have enough evidence to allow for this DWPE, detention without physical examination, of those products that appear to be in violation of the FDA's laws and regulations. And many times it could be related to your manufacturer, and you act as the import record. So it's not that importer or record is on the import alert, but your manufacturer, your supplier in other countries are. So you will want to check before you import anything that if the imported products are subject to the DWPE on the import alerts. Next slide, please. I will be So the importation process is finished here. My presentation finished here. I will give the forum back to Jim and to talk about some FDA enforcement actions.
Thanks, Michelle. So, I just have one slide here, but I wanted to give an overview of actual FDA enforcement actions. Sometimes people think a warning letter is an enforcement action, which technically isn't true. When you talk about an FDA enforcement action, that's an action where FDA is trying to get some sort of remedy because of a violation. So there are basically 4 different categories of FDA enforcement actions. The Food, Drug, and Cosmetic Act provides that for certain violations, FDA can seek a civil money penalty. And that is not for all violations. It depends on the product. I will tell you that, technically for violations relating to medical devices, any violation, FDCA violation regarding medical device can subject you to a civil money penalty of up to $31,076 per violation. As a practical matter, FDA uses the civil money penalty process primarily with respect to tobacco products, either for retailers who are selling tobacco products, who have sold a tobacco product to an underage purchaser. So used to be 18, Congress changed the law a couple of years ago. Now you have to be 21 to buy a tobacco product in the United States. So that is the bulk of FDA's civil money penalty actions are in respect to the sale of a tobacco product to underage purchasers. FDA has recently started using civil money penalties for the sale of unauthorized tobacco products. So products that don't have the proper FDA authorization, FDA has started to use the civil money penalty process there. While FDA can use it for any violation regarding a medical device, can use it for certain violations regarding drugs, FDA typically doesn't use that tool. They have, but it's pretty rare that they do. Most FDA enforcement actions are injunction actions. And for these other three that I'm going to talk about here, injunctions, product seizures, and criminal prosecution, the difference between those and civil money penalty actions is for injunctions, product seizures, and criminal prosecution. The FDA actually has to go to the United States Justice Department and ask the Justice Department to bring the action, because all of these latter three types of actions are brought in a federal district court. And the FDA has to, by law, FDA, when it has a case in federal court, has to be represented by the Department of Justice. So technically, the Department of Justice has the final say whether any of these three actions will be brought. The way the process works is when FDA wants to bring one of these actions, it asks the Department of Justice to bring the action. The Department of Justice is not required to bring the action. There are occasions where the Department of Justice looks at the allegations and the evidence and decides that it's not appropriate to bring the action, or it's the violations are just not significant enough. But in most situations where the FDA asks the Justice Department to bring the action, the Justice Department will do so. So an injunction action is a federal district court action where typically involves a facility, a manufacturing facility, typically involves some sort of problem with the product's manufacturing process or the labeling, where the FDA will file an action and would ask the court to issue an injunction against the company, which is a court order, which orders the company to cease operations. I mean, FDA calls this an upfront shutdown, where the order says you may no longer sell your product, manufacture your product, until FDA is satisfied that you have fixed your problems. And if you violate that court order, that's criminal contempt of court, and you could be in even bigger problems. Typically in injunction actions, a lot of times what the defendant will do is will agree to an injunction. It's called a consent decree, which is the same thing as an injunction. It's just you're agreeing to it. It's kind of a settlement agreement that is public, that is filed on the court's docket, where you will agree to certain situations. And when one of those injunctions is in place, typically what it means is you are required at your own expense to hire a third-party consultant to come in and certify that you have fixed your problems, certify that to the FDA, and then typically what will be required is at certain periods of time going forward, usually on an annual basis, again, a third-party consultant comes in and does an audit and makes sure that you are still in compliance with the law. And if at any time the FDA decides that you are no longer complying with the law, the FDA can just order you to shut down again. So it's a big deal to have one of these injunctions put into place. Product seizures are typically, FDA doesn't do a whole lot of these anymore, but that's typically when there's a problem at one specific maybe factory or a warehouse where the FDA has discovered a big stock of products that has problems. Could be food that's spoiled or adulterated, something along those lines, where federal marshals with a court order will actually go in and seize the products, and then you are entitled to a hearing where the FDA would have to prove that there's a problem with this product and the product cannot be fixed or reconditioned to bring it in compliance, and the judge can then actually order that the product be destroyed. So those are product seizures. And then in the most serious situations, and this is typically involving like deliberate misconduct, fraud of some sort, counterfeit products, the FDA through the Justice Department can bring a criminal prosecution, and that can result in a misdemeanor conviction or a felony conviction, really depending on how serious the situation is. And the FDA does have its own, it's called the Office of Criminal Investigations, OCI, which are federal law enforcement officers which do investigate really serious violations of the Food, Drug, and Cosmetic Act. So those are the main type, those are the enforcement scheme that FDA has once you get beyond, you know, a warning letter. You know, obviously, if you're in a situation like that, you need to be consulting with counsel. So that's what I have for enforcement actions.
Yeah, I can see from the panel here that we have received, you know, actually a couple of questions. To the extent that we have time here, we can kind of talk about some of the questions that you guys have here.
Hey, Michelle, do you want me to read them? I think they're for you. So.
Okay. So I can do. You know, to the extent that we cannot answer all your questions like thoroughly, we'll follow up with you after the webinar. And of course, you can send us, you know, additional questions by email, and you have our contact information in the handouts. So the first one is, can you please clarify the difference between importer worker and the importer as defined by FDA when registering a facility, for example, as an importer? Now, I will let Jim to talk more about definition of FDA. What is the importer? When we talk about importer workers, it is a transaction or shipment specific. So it will be looking at this shipment. Are you the importer worker? And the importer worker will submit the entry form called 7501 form with customs, and the importer worker for that particular shipment will be the person that is liable for all the liabilities in violation of the custom laws, including avoidance, the circumvention of tariffs, HTS code, misclassification, and anything like that. So any of those tariffs that need to be paid back to custom, it will be on the importer workers. As far as I understand it, FDA's importer definition for registration purpose is not necessarily transaction specific. It's more like, are you, you know, but I will, or it has a broader and different kind of definition about who is the importer. Importer worker needs to be shown on the paper. Jim, do you have anything to add here?
No, I don't have anything to add.
Okay. So the next question. Sorry, just trying to pull all the questions here. Let me open it up. I see a couple of questions. We have been told by brokers when there is an FDA hold that the goods can't be moved more than 50 miles from the port of entry. Is that correct? So I think that generally is correct. What happens often is that a product being conditionally released by customs, and there's a gap time between the FDA hold and the conditional release by customs. And so I've seen times that before, you know, the custom broker sees that it's FDA hold, that custom broker already moved the product from one warehouse to like maybe many miles, more than 50 miles, and then back to the destination warehouse. And then I will receive an email from FDA and say, and if we kind of, you know, reach out to FDA, the FDA reviewers, or the FDA reviewers can reach out to us, and they will say, this is being held by FDA. Why is your product at X, Y, and Z warehouse now? And you would just kind of explain, oh, that's what happened. FDA understands it. But yeah, I mean, that's that's what happened. But FDA doesn't their super, like, you know, some designated area or something like that. But you do not want to move your products when you know there's FDA hold. You don't want to get in trouble. Okay, next question. Hopefully that makes sense. Next one is, I think it's for you, Jim. Is the pet's cosmetic must be registered from Europe?
I'm on mute there. So first, it's a good question. I'm glad somebody asked about cosmetics. So cosmetics traditionally has been, like, even though it's in the name of the statute, the Food, Drug, and Cosmetic Act, traditionally that's been the one product area that FDA has had the least authority over. It's been a frustration for the agency for decades. At the end of 2022, Congress passed what's called the Modernization of Cosmetics Regulation Act of 2022, which doesn't immediately go into effect. It changes and expands FDA's authority over cosmetics, and certain things take effect at certain periods of time, typically 1 or 2 or 3 years after the law went into effect. So cosmetics in the past, you did not have to register your cosmetics with the FDA, but that is going to change. That I think it's by the end of this year that if you are a cosmetics manufacturer, you have to register your facility with the FDA. You also are going to have to register your cosmetics ingredients with the FDA. There are other things that are going into effect. Other things that are going to affect over time. You asked about pet cosmetics, and you can see I'm looking at my copy of the Food, Drug, and Cosmetic Act here, because that's a good question. I don't know that a pet cosmetic is actually an FDA-regulated product. I can find out, but I've actually not heard of that being an FDA-regulated product. There are animal drugs, but I'm not sure if cosmetics are something that fall within the definition. So what I'm going to do is I'm going to get back to you on that, whoever submitted the question, because I want to make sure I have the right answer. And sometimes what FDA will do, because I know the FDA does this with people will try to market something called a dietary supplement for a pet. And FDA's position on that is, well, technically, there's no such thing as a dietary supplement for a pet. We would regulate that either as a drug or as a food. And what I would like to look into is what FDA does when it's a cosmetic product for an animal. Because I'm just let's see. Yeah. So as I'm looking at the definition of cosmetic, it's an article intended to be rubbed, poured, sprinkled, or sprayed on, or otherwise applied to the human body. Blah, 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 blah. So when you read the actual definition in the statute, cosmetics, it's something that's used on humans, not on animals. But I do want to look into what FDA says at all, if anything, about if it's a cosmetic intended for a pet, because FDA might take the position that that's a drug, an animal drug, but I will get back to you on that.
That's a great question. And so next question, we are running to our 1 hour top mark here. I will give you the CLE tracking code at 1 o'clock, but I do want to get to this question. And there are a couple more questions that we may not be able to get to. And Jim and I will follow up with you after the webinar. So this last question that we'll talk to is, how long does FDA keep companies on the importer list? For example, are they removed after a certain number of years? Well, no, if you are on, it's indefinitely. I mean, unless FDA decided that import alerts can be removed or taken off entirely because that category of violation doesn't happen anymore. Or if it's a countrywide import alert, if they decided that whole country It's not subject to the importer, and nobody else should be on the, no other country should be on the importer. The importer doesn't need to exist anymore. They can remove the entire import alert, but if you are on import alert, unless you file a petition to remove yourself from the import alert, you will be on like indefinitely. So it's 2 o'clock now. If you are seeking CLE for today's program, the tracking code is T as Thompson TH1016. TH stands for Thompson Hine, the initial TH1016. If you are not currently receiving our updates and invitations, we invite you to go to the Thompson Hine website and register to receive our mailings under the publication tab. I also encourage you to visit our blog, thompsonhinesmarttrade.com. Thank you for all your interest in attending today's webinar. Enjoy the rest of your day and stay well.
Thank you.